this time the defense moves for a judgment of acquittal on both counts. I will work with the kidnapping charge first. The state's charge of kidnapping. First, kidnapping is a specific intent crime, which means that at the time the alleged kidnapping took place, it had to be the intent to kidnap, and typically the intent is to commit something else. So it's charged right now that the intent was to either further the commission of another felony or to harm or terrorize the victim. Now, as far as the evidence that has been presented in this trial about the kidnapping, we have essentially the two neighbor witnesses who presented any testimony whatsoever about the kidnapping. Both witnesses describe her as, stomping around in the yard, throwing things into a car. The first witness described her swinging her arms around a lot, both away from Collin and as she approached Collin, and even up until she was so close that Collin could reach out and touch her. So at that moment, we have the testimony, which seems to align between both witnesses, that Collin grabbed his mother. She exclaimed, according to witness 1, "Let go, you're hurting my hair." Witness 2 did not hear anything. And then, although it has been argued that Collin dragged her into the house, the actual testimony from the witnesses was that the two went into the house. So if we pause it right there, at this point we have what is arguably a misdemeanor battery. We have what could be a defensible touch on Collin's part, that he, in response to his mother swinging his arms in his face, reached out and grabbed her. And whether or not he had the right to do so, either way, it would either be a defensible battery or a misdemeanor battery. When examined on cross-examination, neither witness said that they heard Kathy exclaim anything about not wanting to go into the house. They did not see her fighting to not go into the house. They saw her legs moving. They saw her go into the house with Collin. And that moment is what has been alleged and the only evidence that has been shown of a kidnapping. So at that point, Mr. Griffith's specific intent to kidnap has to have been completed. We do not have that in this case, Your Honor. We have not heard any evidence that there was any fight on Kathy's part, any unwillingness to go inside of that house in that moment. We know she didn't want to be touched at that time, that she said that you're hurting me. We don't know if she was upset about him having his hands on her. We do know that he was touching her too hard, essentially, is the evidence that has come forward. And again, that would be a misdemeanor, which would not be sufficient in any case to charge a kidnapping with. So we move on from there. What evidence have we heard in this case that is going to turn this from a misdemeanor battery to a kidnapping? Well, we ultimately have a deceased person in this house. We have, the fact that she is found in the house roughly an hour and 15 minutes after this incident occurred, with the yelling outside and the touch on the upper torso. And we have no evidence of what happened inside the house. We have no evidence that Kathy was not in that house, or wasn't in that house against her will, that she remained in that house against her will, that she was not able to move in that house. The only evidence we have of anything that happened inside that house is the body itself, with the forensic evidence that has come into play from that, and Mr. Griffith's 911 call. Mr. Griffith's 911 call states that there was an extended, prolonged fight, and that they ultimately, there's the accident that she fell on the knife. There is no mention that that fight started outside of the house, that it continued inside of the house, that it continued all the way up until the moment of her death. There is no evidence that she was dragged immediately from the porch into the house and murdered at that time, like the state may offer as an alternative. We have not heard that from any witness. We have not seen that in any evidence that has been presented. So again, the evidence of the kidnapping turns back to the misdemeanor battery, that she was touched, that she exclaimed upon the touch, and that she continued into the house without doing anything else to say that she did not want to go in that house. All of the case law on kidnapping gets into whether or not that the crime itself was completed, whether it was necessary to complete the other crime if there is another crime that's charged. But all of it, every case, includes proof that the victim was held or moved against their will. And we don't have that in this case. So we are not even at the starting point of whether or not you should consider a phase-on test or anything like that that falls under the kidnapping line of cases, because we have not heard a single piece of evidence that says that Ms. Griffith did not go inside of that house willingly. So for that reason, we are asking for a judgment of acquittal on the kidnapping charge. As far as the first-degree murder goes, Your Honor, the evidence that has been presented so far of premeditation is that Mr. Griffith had a conversation with his grandfather in which he said that he wants to kill his mother, that he wants to slit her throat, according to the witness. We have the testimony from the officers who stated that he said things like he wanted to kill her. We have the testimony of Mr. Griffith himself in the back of the car where he said that he could kill her. Again, other than Mr. Walantis' testimony, every one of those officers, every piece of body cam footage, every piece of car footage that we've seen is conditional. That if violence occurs, if she comes at me again, if anything, then premeditation does not override someone's right to self-defense. If it did, then every officer who ever acted with lethal force would be charged with a capital crime. They are trained to respond to situations, and they know how to respond to that situation. That knowledge does not create premeditation. The fact that Mr. Griffith thought about what he would do in a situation where he felt that he was being threatened, and even took it as far as to how he would do it, does not create premeditation. That is not a crime. That can still fall within the realm of self-defense. The only piece of evidence that we have that would go against that is that that he didn't have enough marks on his body. I mean, the state offered physical proof that he had injuries. They have argued that those injuries were insufficient in opening. We have not had any witnesses testify to the extent of Collin's injuries, what could have caused those injuries, what could not have caused those injuries. In order for this to be a first-degree murder, we have to have premeditation, which so far I do not believe the state has proven, and we have to have a waiver of self-defense in some way. If there is just a waiver of self-defense, if this was a fight that got out of control, I apologize, do you have to... Yes, Your Honor. I understand. Okay. Your Honor, I was speaking as to the if this were a fight that got out of control and Mr. Griffith had started that fight, then this is arguably second-degree murder, as would be charged, that this was something that was created inside of the moment, that the decision to kill did not require adequate reflection, and that this would be a second-degree murder. So we have I don't believe that the felony murder should be considered, because I don't believe that the kidnapping is sufficient to reach that, and there's been no evidence that the kidnapping was a continuous crime. Again, we have proof of her injuries showing that there was some kind of fight. We have proof of Mr. Griffith's injuries showing that there was some kind of fight. We don't have any proof that Mr. Griffith made a previous decision to kill in this moment, that this was orchestrated in any way by him. In fact, we have the opposite. We have Miss Griffith showing up at that house without permission to do so, being angry as soon as she gets there and never cooling off, according to the witnesses. At the time that she gets into his face, Mr. Griffith acts. From that moment forward, they go inside the house, and it's unclear what happened. We have no evidence. We have no forensic evidence that showed what happened inside of that house to show that this was something that was planned, that this was something that was thought out, and that this matched any kind of a decision that Mr. Griffith had made. If anything, it is more likely that this fight escalated once the parties got back inside. This fight escalated, that there was at some point, someone gets a knife, and then Miss Griffith ends up dead. And to me, that is the realm of a second-degree murder. That is a standard fight that goes too far, and that is what the jury should be considering. They have not had any proof, again, that would rise to the level of premeditation. They have not had any proof in this crime that anything else would enhance this crime to a first-degree murder. This is a second-degree murder and a battery that happened beforehand. And it is arguably self-defense on either issue, but again, I will concede that by raising self-defense, we have created a circumstance where the jury has to make a finding of fact. So I'm not arguing that this entire incident can't be considered by them. I'm just arguing that it should not be a kidnapping, and it should not be under the felony murder statute, and it should only be a second-degree murder.
Your Honor, as it pertains to the kidnapping, from two independent witnesses we saw and we heard that the defendant grabbed Kathy by the hair. He did that forcefully. And what did he do? He dragged her / pulled her in against her will as she was protesting and yelling loud enough so that one of the witnesses could specifically hear from inside, looking out the window, "Stop, Collin, you're hurting me." At which point the defender dragged her / pulled her into the house, which was clearly forcibly, which was clearly against her will. And then once he had her inside, of course, he confined and/or abducted her from outside into inside and/or imprisoned her. The last place that she would want to be would be inside after being yanked inside by the hair by her son, who has told multiple people, obviously, his intention to kill her, when he's furious, when she had just sent him the text message regarding the other person that he murdered by shooting that person in the chest and then in the head, and when she threatened to come forward and tell the officials in Oklahoma and elsewhere about the defendant confessing that it in fact was a murder, that it was not self-defense, and that he had planned it, the defendant's anger level was through the roof. So once he gets her inside, he has no prying eyes, he has no witnesses, and he can inflict anything and everything he wants to on his mom. So once she gets yanked from outside to inside, and mind you, he had her by the hair, which there's no way she could get loose from that. So as he yanks her inside, once that door closes, that was clearly the beginning of the end for her. Now he's all alone with her, with no witnesses and nobody that could help her. And his intent was to inflict bodily harm upon his mom, or to terrorize her, and or to commit or facilitate the commission of the murder. Judge, once the defendant gets her inside, there's not going to be an hour and 15 minutes of these two people talking and having a rational conversation. It was an absolute powder keg that went off immediately. So the defendant, as we come now to the first-degree murder, you can see the pathway by which the defendant pulled her by her hair, dominated her physically. He's 6'2", outweighs her by, who knows, maybe 30 pounds or so. He's bigger, he's stronger, he's younger. He had to go to the butcher block, take out the knife of his choosing, continuing on with the premeditation, and then stab her, not just any place, not just cut her, but stab her in one of the most vulnerable parts in the human body, which was right in the neck. And as we heard from Robert Willantis, the defendant accomplished exactly what he wanted to do for so long, which was to stab her / slit her throat, watch her bleed, and watch the life drain from her, which is exactly what he was able to accomplish with premeditation. So Judge, I would rely upon the facts and the evidence of the whole record and ask that you deny the defense's motion and allow the jury to consider both the kidnapping charge as well as the first-degree murder charge as we go forward, Your Honor.
Your Honor, as to some of the arguments just made, first off, there's been no evidence of anger in the moment on the part of Mr. Griffith. We have the evidence from the neighbor that he was calm, that Kathy was irate, that she was flailing around, and that he reached out, but that his demeanor did not rise, like he didn't start, there was no evidence of rage or anything like that. So I know the state keeps using those words. That's an argument on their part, but that is not the fact that has been shown in this case. As far as the decision to choose a knife, again, that's not a fact in evidence. As far as the decision to dominate her physically, well, we have evidence of bruising. So I guess I would concede that there was a physical altercation, and it looks like Miss Griffith bore the worst of that. But I don't know that dominate physically is something that has been testified to in any way. Again, it's being argued by the state attorney. The size of Mr. Griffith that keeps coming in from the state's words, that he's 6'2", that he's some weight, we don't have any fact on Mr. Griffith's size. I mean, the jury has observations. They can see me standing next to him, and they can tell that he's much smaller than me, and I'll tell you, I'm not 6'2". So I don't think that that comes into play in a decision to, decide whether or not this was a premeditated murder. And as far as the kidnapping, again, the only evidence we have of Kathy's intent is when she shows up mad, when she's throwing things in his car, we have her intent. Yeah, and she had already gone into that house. I mean, she goes in, she comes out with stuff. That stuff was not sitting inside. So we have her not wanting to be pulled by the hair, but again, we don't have any proof that she was pulled by the hair. We have the autopsy of her body. We do not have a single shred of evidence that she was harmed in any way by a grasp to her hair. There's no bruising of her scalp. There's nothing like that that has been shown. So she said, "You're hurting me," loudly enough to be heard. That's a battery. She did not say, "No, don't take me in there. I don't want to go in there. Stop." She was not dragged. I asked the witnesses specifically if her feet were going up the stairs, and they said yes, that she was moving her own legs, that she went into that house. So I understand the state's argument that they are making, but it is argument. They are not using the facts that have been shown. And the fact is that this is not a kidnapping. This is a misdemeanor battery, and then a fight that happened inside, and that fight led to a death.
Taking the evidence in the light most favorable to the state, as I must, hearing on a motion for judgment of acquittal, I do find that the state has made a prima facie case as to each element of each offense, and the motion is denied. Is there anything else we need to discuss before we bring the jury in?
Judge, when do you usually do a jury instruction conference?
After everyone rests.
Okay.
Was there something in particular you
No.
wanted to address now?
No.
Are we ready for the jury?
I believe so.